My name is Jovan Kurbalija. I'm director of DiploFoundation and head of Geneva Internet Platform. And I'm very, very honored to welcome you all to our traditional session that we organize with the Water Hub and University of Geneva on the question of international water law and transboundary cooperation. Today we have with us a really prominent group of experts. We have Dr. Mara Tignino from the University of Geneva, a reader in Faculty of Law, and also lead legal specialist for Platform for International Water Law, Geneva Water Hub. We have with us Dr. Komlan Sangbana, originally from Togo, now legal officer and secretariat of the United Nations Economic Commission for Europe here in Geneva, dealing with the Water Convention. And last but not least, we have Dr. Dinara Zinganshina. I hope I pronounced the last name correctly. The first name was very easy because it associates with the famous mountains in the Balkans. She is the Deputy Director of a Scientific Information Center of Interstate Commission for Water Coordination in Central Asia, and also member of Implementation Committee of the UN Economic Commission of Europe Water Convention. As you can see, we have very, very competent panel for today's discussion. And today's discussion will focus on, obviously, transboundary cooperation, but just for those of you who are not familiar with this topic, here are a few numbers that we collected in the preparation for the session. There are 280 transboundary water courses serving almost 40% of the world population. Then you have, just behind me, you have the Danube water basin, which collects no less than 17 states. I was a bit positively surprised. I know the Danube crosses throughout Europe. And in addition to this water basin, we have also in Asia, Mekong River basin, and we have Amazon basin, again, connecting many serving seven states. And I'm sure that these days you are also familiar with the discussion on the Nile water basin, for which somehow I don't have a graphics. No, I don't have a graphics, but we'll share during the session, which is the field with many intensive discussion on transboundary water sharing. And I'm sure that this broader context, which is cross-regional from Asia to Africa to Latin America and Europe, can bring convergence in our discussion, seeing what could be learned from each other, in particular from the rich experience in the United Nations Economic Commission for Europe. There are a few rules for our discussion. You can pose the question in chat, and our moderator who is following discussion will bring this question to our panelists. And that's as simple as it is. And we usually have very intensive and interesting and exciting discussion. And there is no reason why we don't expect the same today. We have 48 participants in the room, and some of them on YouTube. And we have a first comments in the chat. But from Marco Lotti, who will be moderating our chat. Without further ado, I would like to invite Mara. Mara, please tell us more about this context for today's discussion before we move to our panelists, Komlan and Dinara. Mara, over to you.
Thank you, Jovan. It is always a pleasure to have this collaboration with DiploFoundation, the Geneva Internet platform. So no, it is quite a tradition to have this webinar. So I would like to set the context. Maybe in preparing this presentation, I was thinking that I put a question mark. It is not. It international water law an effective tool for transboundary water cooperation. So maybe I would like to start giving a short answer, saying that international water law can be an effective tool together with many other factors. So, international law, international water law, it is one of the necessary instruments to have transboundary water cooperation, but not alone. It is necessary to have other elements. Of course, political will, but also science. Science is very important to have the scientific and technical data about the hydrological basin. So maybe I would like to share my, if it's possible to share my presentation. I have just one slide with few points. So the next slide. So I would like now to share some key points that make the international water law an area of international law. Sometimes it is said that it is the same that international environmental law, but I think that it is a specific area. So sorry, there are some words here. So we have different frameworks at the universal, regional, and basin levels. So international water law is made by a different set of norms. Of course, with the following presentation, we will focus on the universal global framework that is given by the UN Water Courses Convention, the UNEC Water Convention, but we have also regional and basin agreements. Now you showed some maps, and for example, now with the Danube, we have two conventions, one focusing on navigation and one on more focused on environmental protection. And we have also now international water law provides the general principles guiding the sharing of transboundary waters. And of course, it can be said the principles like equitable, reasonable use and the no harm principle are vague principles, but these should be read, this generality of the principles should be read in the context of the specific characteristics of the basins. So general international law provide general principles that then are specified, that they take a concrete form at the basin level. Then we have also international water law, not through the specific agreements. The basin agreements provide the joint institutional mechanisms, so the river basin organizations that are, with a term that is often used in these days, are resilient institutions. In fact, even during armed conflict, these institutions have continued to be a functioning structure, and an institution that often is presented as a model. It is the Senegal River Basin Organization. Then this mechanism also provide the setting for the exchange of technical and scientific data between riparian countries. And I would like also to mention that the scientific data are also the first instrument to set cooperation between. So when we start often cooperation between countries, this cooperation begins with the exchange of technical and scientific data between the riparian country, because we need to know more about these shared resources, and in particular in the case of aquifers. We have mentioned basins, but one of the resources that is like a northerly of international water law a little bit is that they are aquifers. We have only 7 agreements around the world, and I would like to mention that together with the UNEC Water Convention Secretariat, we are working on a transboundary aquifer in West Africa. So no, we try really not to support this cooperation on groundwater resources. Then another point that it is important that the international water law can provide, it is the prevention of water disputes, so through joint institutional mechanisms, so supporting the dialogues, the negotiations between countries, and in international water law provide some general rules of the game for the cooperation between countries, so it can be one of the tools for the prevention of water disputes. And also the international water law, international law in general, provides the means for settling water disputes. So the most often used method of settlement of disputes, it is a negotiation, but we have also judicial means like the resort to the International Court of Justice or the arbitration tribunals. And with the presentation of Dinara, we will see also another means of preventing of preventing water disputes through the implementation committee of the UNEC Water Convention. Then the last point that in my first version of presentation was also with a question mark. It is public participation. So I think that this last point, the participation of the public, so the individuals, communities, or also indigenous communities, is still a weak point of international water law. So there are some conventions that contains this point. For example, in the agreements in West Africa are very progressive in this area. But I think that the participation of the public in decision-making process related to the uses of transboundary water resources should be strengthened. So if I come back, I conclude with this. So if I come back to the question mark, yes, international water law can be an effective tool for transboundary cooperation, but we need to have other factors like political support and also science, so scientific data that support our knowledge about water resources. Many thanks.
Thank you, Mara, for an excellent intro. And you triggered already a few questions, which I would like just to pose as idea, maybe for your reflection later on, or maybe by Komlan and Dinara. You outlined this sort of trinity: political will, international law, and science and data. Obviously, today we discuss international law, and you argue that it is effective tool, and we'll hear from Dinara and Komlan if they share your view. But one point really resonated with me: it's scientific data. How much of scientific data we have? I'm based in the building of WMO, and I know that there is very intensive discussion on data sharing. Is there discussion between, let's say, regional bodies and WMO when it comes to the hydrological data sharing? That would be interesting to hear, this interplays between different actors. But because what we've been hearing from Road to Burn discussion, Road to Burn is related to the World Summit on Data, is that there is not sufficient data. Is it the case in the water, in hydrology and water courses, or it's not? Let's reflect on that. That's an interesting issue of cross-institutional cooperation and availability of data as a basis for lawyers to regulate these issues. Komlan, I'm sure you agree that international law is an effective tool, but let's let's share with us more insights from the trenches of the international law, from the Commission. Over to you.
Thank you for having me. It's a real pleasure to be part of this discussion, and I would like to express first my thanks to Dr. Mara Tinino, the platform, and also the Diplo for having invited the Water Convention Secretariat to address the topic of the global opening of the Convention on the protection and uses of transboundary water courses, international lakes, quite a long name, but we can generally call the Water Convention, and its role in strengthening transboundary water cooperation. So, could you share my, excellent. So, well, next slide, please. Let me start with this quotation of our General Secretary, Mr. Antonio Guterres in 2018. I quote, "The global opening of the Water Convention, the accession of the first countries from outside the UNICE region, namely Chad and Senegal, and the momentum in support of the Convention are promising developments, along with the Convention on the Law of the Non-Navigation Uses of International Water Courses. The world has the ability to strengthen the rule of law in transboundary cooperation worldwide. I call on member states to join both conventions and to strive for their full implementation." Fin de citation. Here, the role of global conventions under the umbrella of the United Nations is clearly spelled by the Secretary General: strengthen the rule of law in transboundary cooperation worldwide. Two questions emerge: why and how? The why, the first, we can find the response in the level of transboundary cooperation in the world. So we know today that only 17 countries worldwide have all their basin covered by operation arrangements. Therefore, there is an urgency to strengthen transboundary cooperation. And the second question is, why do we need global convention to play such role, strengthening the rule of law? Perhaps next slide. So I will not spend too much, but just to give you some key points. First, support, not replace. Both to not substitute existing obligation, instead clarify, reinforce, or fill gaps at different levels. That's really clear in terms of how obligation can articulate. We can come further to explain this. Secondly, foster harmonization of law and applying principle between countries, basin, and regions. We have, for instance, some basin where riparian countries are from different regional integration community. I will take the case in Africa, for instance, for the Niger basin, Niger basin, where we have some countries members of the Economic Community of West African State and others Economic Community of Central African State, and both communities have their own legal policies dealing with water issues. So those global conventions can help to harmonize law in both regions and support transboundary cooperation there. Third, consolidate, clarify, develop customary international law that applies in any case, and strengthen implementation via platform for sharing experience, good practices, strengthen profile of transboundary water cooperation at the global level, and foster synergies with other global initiatives, such as we can take the case of climate change. Next slide. Now, how the Water Convention as global convention strengthen concretely the rule of law? So, well, the real advantage of the Water Convention and what makes this tool unique compared to the 1997 Water Courses Convention, which is also really important as a tool, is that the Water Convention has this legal and institutional framework, which offer a unique intergovernmental platform under the umbrella of the United Nations to discuss transboundary water cooperation issues, contributing to sustainable development, peace, and security. And we've seen in the last decade that more than 100 countries participate to our activities, exchanging experiences and knowledge to prompt progress in cooperation. Next slide. But moreover, the important development under the Water Convention in the recent year is undeniably its global opening to all United Nations member states, following an amendment operation since March 2016. As of today, 44 countries are party to the Water Convention, with 3 new acceding countries from Africa, Chad, Senegal, and Ghana. And more than 10 countries are in the accession process, and some at advanced stage, such as Iraq, which have just passed the law at the parliament last month, or Guinea-Bissau and Togo. I think it's quite important to recall that while the Secretariat of the Convention is served by UNICE, the Convention is first of all about parties, which meet regularly in the framework of the Convention bodies, such as the meeting of the parties and several other subsidiary bodies. Then it is important to keep in mind that those bodies are the Water Convention's bodies and not UNICE bodies. As a legal and institutional framework, the Water Convention is active in strengthening transboundary cooperation. It requires parties to implement. Next slide, please. Yes, it is required parties to implement their obligation. This highly contribute to enhance national water governance and reinforce transboundary cooperation. The compliance is promoted through regular reporting mechanism, and we have an implementation committee which facilitates the implementation of the Water Convention. I will let Dr. Dinara will spend more on that. And other means of action are capacity building activities and projects on the ground. As you can, next slide. As you can see in this map, the Water Convention is already quite active in the ground with many activities in some countries and based in, notably in many parts of the world. And given the current interest, the activities of the conventions are likely to increase and intensify. Now, let me just reflect on two concrete projects which illustrate how the convention start to have impact at the global level outside the UNICE region. Where is UNICE region? Next slide, please. The first project came from a request from the Economic Community of Central African States, and which have support by Chad as NUI party when the Chad acceded. So we received this request to help ECAS to develop a regional framework for the prevention of conflict-related transboundary waters in the region. And when we talk about the Central African region, it's about 16 transboundary rivers, lakes, and aquifers, among them Congo River, which is the second largest river in the world in terms of water flow. So we support ECAS and the ECAS countries, so 11 countries there, to develop this regional framework. And we provide them with training in international water law, and also facilitate the negotiation of the convention. And as key output, we have this convention on the prevention and peaceful resolution of conflict related to the management of transboundary water resources in the region. And the convention was adopted by the head of state in July of this year. So we have now a framework in the region who can help countries to strengthen and foster the transboundary cooperation. The second project in the ground, directly related to the accession of NUI party, is a project on the Senegalo-Mauritanian Aquifer Basin. And this SMAB initiative owes its origin to Senegal when becoming party to the Water Convention, and expressed its interest in promoting transboundary cooperation on this aquifer, for which estimated population of 15 million inhabitants depend on for the resources for their daily lives. So a sustainable cooperation is really essential, since the groundwater resources is under pressure due to the increase of water demand with population growth, urbanization, and agriculture. So the Water Convention, with many partners, and in particular the Geneva Water Hub, we are now supporting Senegal and the Aquifer state, as well as the main basin organization, to develop a cooperative project on the shared resources. So as key outcome, so far we facilitate the establishment of a regional working group in April of this year, composed by countries of the SMAB and main river basin organization. And the mandate of this regional working group is really to induce transboundary cooperation and to advise the state on the SMAB to develop or establish a sustainable mechanism for concerted transboundary management of the SMAB. And just this week, we end up the second meeting of this regional regional working group. Just yesterday, and this meeting ended up with a vision for transboundary cooperation around this map and the main operational line for the implementation of this vision. So next slide. To finish, I would like to conclude by coming back on the main reason that leads to global opening of the Water Convention. While the growing interest from countries outside the UNEC was a key argument leading to this opening, such a decision was taken by parties based on the Convention success in strengthening transboundary water cooperation at both political and technical levels in the UNEC region. And now to apply what parties thought is that there is a need to apply the principles and provisions worldwide and share experience of the conventions, as they believe that the implementation of the Water Convention at the global level will be crucial for international peace and the prevention of conflict, as the situation of water resources is projected to aggravate in the coming decade. But also learn of the world is not in unidirectional approach, but that should lead to a win-win approach. And finally, with its institutional architecture, they saw that the Water Convention has an effective and much needed intergovernmental platform under the umbrella of the United Nations which can contribute to broaden support for transboundary cooperation and help to develop jointly solutions to common challenges, existing and emerging ones. So I will stop there and invite perhaps the last slide. I will invite all participants. If you want to know more, we have just developed these FAQs, frequent asked questions, to provide a very detailed responses to some questions that emerge around the Water Convention. So I invite you to go to click on the link and to get there to get also more information. Thank you.
Thank you, Komlan. It's great for me as a lawyer to hear that there is one field where the law is applied when it's making an impact on the ground, because as we know, in some other areas, international law is in a crisis. But it's great to hear that in water field there are some important and good developments. You mentioned a few issues that are important. You mentioned conflict resolution, public participation, and I will get back to that previous question on data. Probably in the Q&A, our panelists and participants, we have now almost 75 participants on YouTube and here in the room. Invite them to comment on this question of cross-cutting issues. Therefore, that would be great to hear your reflections, and also very interesting example of extending the regional convention to the global level with a specific body which is not necessarily UNECE, which is very important, but it's a water secretariat. Unlike, for example, in question of Council of Europe Convention on Cybercrime, where exactly this issue is controversial. Therefore, congratulations for overcoming that potential risk in extending the coverage of convention. Dinara, now we move to you and what you prepared, your excellent presentation, and also some other reflections. Over to you.
Thank you very much for having me, and I'm really pleased to address you today on the role of the implementation committee under the UNECE Convention. I think Mara and Komlan set a wonderful scene explaining what is international law and what the role of the UNECE Water Convention. So my task is more specific, to introduce you to the implementation committee, which actually was established in 2012 on the request of the parties who had the difficulties in implementation and compliance with the convention. And I think the beauty of the convention, that it's very responsive to the needs of the parties. So the implementation committee came as a response to this request from the countries. And the objective of the committee is to facilitate, promote, and safeguard implementation, application, and compliance with the convention. And the nature is a very cooperative and building on this cooperative spirit of the convention. So implementation committee was established in 2012, and it had already 11 meetings for the past 7 years. Here you can see the members of the committee, and they're actually experts. It's back to your question about the science and policy interface. And I think here we can see this interface very closely, because under the institutional framework of the convention, you have not only diplomats and decision makers, but also experts and scientists. And I think we see more and more the role of science and expertise in developing international law. So back to members of the committee, it's a very diverse expertise in terms of the legal and technical background. In terms of the geographic distribution, we have members from different regions. And also in terms of the main point that they're not representing the countries, but serve in their personal capacity, although they are nominated by the parties and elected by the meeting of the parties. What's the main functions of the committee? So basically it has 3 main functions. First of all, it's an advisory procedure. What makes this very unique? When the parties or one party or parties together can jointly apply to the committee for the advice if they have difficulties in implementation committee. The another function is the self-submission. If the party thinks that it's unable to comply with this obligation under the convention, or party-to-party submission, if the party thinks that other countries have a difficulty in implementing the convention, then they can initiate self-submission. The committee also has a possibility to initiate the procedure by itself if it becomes aware of any difficulties in implementation or possible non-compliance by the party. And here's the window of opportunity for non-governmental actors and public participation. Even though the committee does not have the separate provision for communication for the public, but through the committee initiative, the public can apply to the implementation committee. And in addition, the committee may also examine different specific issues of implementation and compliance, and fulfill other functions that might be assigned by the meeting of the parties. And here's some achievements. And I think the biggest achievements already within the nature and structure of the committee itself. And this is unique advisory procedure, as I already told. I think the committee provides a forum for the parties and for the countries in general to get competent advice on all possible difficulties they might have. And in this forum, they are not defenders of the individual interests or positions, but rather together with the members of the committee, they are a collective of solution seekers. And I think it was very prominent in this advisory procedure that we're considering now, that 2 countries looking for joint sustainable solutions of the difficulties that they have. And I think also very important that the committee can provide multi-governance context. The countries might have the Bayesian wide framework or agreement, but still use the opportunities provided by the Global UNEC Convention. And another function and another role that the committee plays is the important fact-finding role. It's again back to your question about the data, about the monitoring. What we're experiencing now with this submission on advisory procedure exactly relates to the question that you raised about the lack of data, lack of reliable data, lack of coordinated data that both countries can use in their interaction between each other. So now we're considering the committee-initiated advisory procedure by the request of Montenegro concerning possible difficulties of possible transboundary impact of planned construction of small hydropower plants on the Sijevna River in Albania. and Albania immediately consent to this procedure, and they, as I mentioned already, working together on possible solutions. Another feature of the committee is the greater role of non-state actors. As I already mentioned, NGOs or non-state actors can be nominated by the countries to be a member of the committee, and also committee can consider information from the public. The committee contributes to better implementation of the convention. For example, the members of the implementation committee was very much involved in designing the reporting under the convention and reviewing the national reports of the countries. It's a really rich source of information about the states of implementation of the convention. And now we're also working with the different expert and drafting groups under the convention to design different guidelines, for example, transboundary water allocation guidelines. And finally, I think the committee plays a very active role in promotion of international law in general and cooperation. Now the legal board under the convention is not operational. That's why the committee supports the secretariat in answering questions from the countries that might be interested in joining the convention. Also, we're participating in different communication and specific events as today, for example, to raise awareness about our possibilities that not only parties but also non-governmental organizations have using this forum. We exchange relevant experience with other relevant bodies that also facilitate and support implementation in different multilateral environmental agreements, and also exchange experiences between joint bodies. Several members of the committee are affiliated with the joint bodies, and we had this possibility to exchange experiences from different regions. So my final slides, it's really summing up the unique role of the committee in promoting transboundary cooperation by making use of the power of knowledge, persuasion, and dialogue. And I think it might be very close to the heart of people in Diplo community, because the persuasion is really something that you are dealing with. And I do think that the implementation committee can also help in this respect. Thank you.
Dinara, you definitely persuaded us that the committee is doing an excellent work. That's thank you for really, really useful and relevant summary, which I found particularly relevant on a few points. On way how the convention and responded to the need. That's not that frequent in international organizations. Sometimes it takes time, negotiations are long. Then what you said, you reflected on data, lack of sometimes coordinated data or data which is accepted by all parties as relevant. Inclusion of non-state actors and general public, and that's particularly important. And this overall question of knowledge, persuasion, and dialogue is important aspect. And we'll start immediately with a question for you, and then we'll move to other questions. You have a question from Sadiq Al-Maliki. I hope I pronounced correctly, Sadiq. Your name, question for Dinara. Is there a difference from a legal standpoint between transboundary rivers and international rivers, resulting in any legal difficulties in international agreements? Over to you.
Thank you for question. No, I don't think that there is any differences between the transboundary and international rivers. I think it's just the use of the terminology. It used to be very popular to name the international river international in the past century, but now it's more transboundary terms is used. But sometimes countries, at least in Central Asia, for some reason, prefer one term or another. But I think from legal point of view, it doesn't make difference if rivers shared by two or more countries.
Dinara, is it used just interchangeable, or some political context is assigned when somebody uses international transboundary, or is just a question of preference? Or
Personally, for me, I think it's a question of preference, but some countries attach to it some political meaning. And if they sign agreement when the term international river is used, as we have in Central Asia, they prefer to use these terms also in regular practice.
Okay, thank you, Dinara, very useful. We'll get back to some of these questions now. But both Komlan and Mara, you can reflect on that, but we have a question, another question for three of you. So you can pick who is going to answer or comment. Is data sharing compulsory or voluntary according to the convention? It's an interesting aspect. Over, Komlan or Mara or, well, any of you. I invite others to join discussion and pose the question as Sadiq and Katarina did. Okay, Komlan, go ahead.
Okay, thank you. Yeah, is it the data sharing compulsory or voluntary according to the convention? First of all, I would like to reflect that the convention established or required some general provision to countries. So I mean, countries are really encouraged to fulfill those obligations when developing their specific agreement in their region. So the question is exchanges of data or exchanges data sharing, is it compulsory in the international water law? Do we have the data sharing or exchange of data as compulsory or customary international? Is a customary international obligation? That is the question that we may also consider, and in this sense. And what we can say is, I think that Dinara can also complement on this as a member of implementation committee, is a required country to really go in the direction of establishing platform for sharing data sharing in the specific agreement. And so in the sense, and if we really consider what the convention what a convention required from parties to the parties to the convention, is really to consider data sharing as a key point, a key aspect to be considered in the agreement that they developed within them on share basin.
Thank you, Komlan. I will just invite also Mara and Dinara to reflect on that, because as you may know, currently there is a negotiation in WMO on reframing a resolution 40 for weather, but also resolution on hydrological data, when there is distinction between essential data in question of weather forecast and the additional data. And it's very, very loaded and controversial issue. This is the reason why I think this question from Katarina is quite interesting. If in this convention, in your convention and other instrument, is it compulsory? Does Montenegro have, or Albania in your example, Dinara, have to share data, or it's matter of arrangement or customary law, which Komlan interestingly mentioned as a possibility to develop? Dinara and Mara, please.
Yes, actually, the convention has exactly the similar provision as in customary law, which states that for all countries, even not for the members of the convention, it's compulsory to exchange readily available data on the condition of transboundary water courses on a regular basis. Okay. So if the data is readily available, then yes, you have to exchange this data. And as everything in this convention, it also relates to due diligence obligation. It's very much also the capacity of the countries, how much data they can collect, then collect and to exchange. And if the countries are ready to exchange the data and I need the data and ask other countries, I can pay for data that it's not readily available, then and receive the data that countries not collecting as on a regular basis. So it's again very much relates to the capacity of the countries.
Thank you, Dinara. I'm focusing on this question because we started with Mara an indication about scientifically driven international law, and what is scientifically driven to a large extent is relying on data, relying on evidence, relying on scientific insight. And it's very interesting what you mentioned, and it would be interesting later on from Komlan to hear, you mentioned capacity development. Is there any capacity development in that realm to bring capacity of countries to collect data and scientific evidence? What Dinara mentioned, if country does not have a data, then somebody has to pay for it. That would be interesting, but back to Mara. Mara.
Yes, maybe just I wanted to add that the question about transboundary rivers, international rivers. We have also a third option that it is chosen by the International Court of Justice, that it used the term of shared water. So shared water resources, it seems even not to put the accent at the fact that rivers don't know borders, so no, they are shared. So just I wanted to add that is a third option that to my knowledge in agreements it is not used the shared water, but the International Court of Justice really prefer this term. And then, yeah, so about the exchange of data, yes, I think that it is very interesting to ask the question if this is a customary norm, and it is also related to the question about the duty of cooperation. So if there is a customary norm of cooperation on transboundary water resources, the exchange of technical and scientific data would be part of this duty. And then I think also that the exchange of data information, so it is really the starting point of cooperation between riparian countries, but also there is another dimension of sharing of exchange of technical data and information in the case of planned measures by a state. For example, in the case of the project of a dam, the communication of the information, and so the environmental impact assessment. And so I think that in that case, we can go further. It is not a customary norm, but we could ask ourselves if, for example, to develop a joint study between country on the environmental and social impact of a dam. Maybe this is the way to go, to have a joint assessment, a joint data and information about the impact of a project on a transboundary river. Thank you.
Thank you, Mara, which you bring another interesting insights here, and it's related to the question of Yaristegui. I hope I pronounce it correctly. Please bring me immunity if I mispronounce the last name, which is very often happening with me. I know it can be annoying, but that's reality. He or she is asking, what is the relationship between the obligation to exchange information and consultation notification? Thank you. Which brings to the Mara's point. He say there is duty of cooperation according to customary law, but then exchange of data information is always contextual. And what Yaristegui said, is it related also to the exchange of information, consultation, and notification? You brought, Mara, exchange of data in context of environmental assessment. Therefore, we have so many entry points where you have the flow of data between parties in agreement. Okay, that's on that issue. Is there any comment in this? And we will be gradually wrapping up our discussion. We will be hearing comments on any point so far in discussion by Mara, Dinara, and Komlan. Over to you, Komlan.
I just
okay.
Just to reflect, sorry, just to reflect what's the relation between the obligation of exchange information. I think Mara rightly mentioned how they're very much related. And my personal preference to talk about the procedural system of cooperation. When we talk about the exchange of information, it also sometimes involves consultation. And when we really see this set of obligation when the planet measures are happening in one or another countries, then we see the whole range of obligation about the exchange of information, consultation, and prior notification and transboundary impact assessment coming in. And you really cannot separate one from another because they're very much linked together.
Thank you, Dinara. Komlan, and then we'll have 2 more questions.
I have 2 more questions. Okay, yes. Now, what I want to say, perhaps just to reflect on within the Water Convention Secretariat, we have like a platform to support the data sharing. I will say that when we talk about data sharing, in particular, one of the key requirements under the Water Convention is really the requirement to establish procedures and mechanisms for facilitate this information and also ensuring the availability of certain data. So in terms of capacity building on the support, yes, of course, we have an area of work and dealing specifically with data sharing, but because when you say also data sharing, it's quite important to link it with assessment as well, monitoring and assessment, and then and data sharing. And we have a specific area of work on dealing with this issue within the Water Convention program of work. And something I would like to say is data sharing is also a problem of have enabling environment. If we will be able to share, we need to have like at least a kind of institutional framework or institutional platform that can facilitate this one. And one of the key area of work of the Water Convention is really to contribute to help countries to set up those platforms to deal with this. I can give the case of the BASEM, the project in the Senegal with other riparian country of Senegal, Mauritania, and Aquifer. One of the key points is dealing with the data sharing, because countries need to share data on the water, this groundwater, the availability of that's first knowledge. They need more knowledge about the resources, and then also share it, and how they will do it. So now we are supporting them to really set up a platform to do this platform of sharing of data on the groundwater resources. So I will stop there. Thank you.
Thank you, Komlan. An excellent point on the platform, and thank you. I hope we can share the links after the session. 3 questions by Haidar Al Hudayb and Ines Zeguil. Let me make a first question from Ines. She says, I work with development banks on implementing water project in developing LDC countries. I face regularly the issue of data scarcity. That's an interesting point. Or stakeholder not willing to share the data. Therefore, even if there is data, not willing to share, that's important. The issue is about who owns the data and if they can make money out of it. Do you consider any incentives to share or holding the data in a general public available data? Then we'll get back to the Haidar's and Ines' other 2 questions. But let's say this question. Therefore, there is a data, but countries are not interested to share for financial reasons because they can get some money for their budget. Any suggestion what we can do with it? Dinara, Komlan, Mara. What could be incentive for countries to share data?
It's a really tricky question, but really interesting.
Because I guess
I think sharing data is first of all about also confidence, building confidence between countries. And something can help countries to in this direction is really to have like a vision, because I'm talking about basin or river basin. If you have some countries who can really reflect or make like kind of projection in the future in terms of investment, that they can retrieve by sharing data or collaborate in this basin organization, that can help them to, they need to see the benefit to share the data. And we need to find a way really to help them to get to this point. So it's mainly about benefit of cooperation, which lead to facilitate data sharing between countries. And yeah, I mean, I would say.
Komlan, in this era when everything is utilitarian, we have to see see how we work on it. But your point is very, very pertinent, that countries have to realize that it's beneficial. Back to Haider's question. In anthropogenic upstream, such as multi-purpose dams, tunnels, and irrigation projects development, which directly impact on the downstream countries, can be included in the initiative and cooperation policy, and what are the international legal obligation on their issues? Over to you. Is the question clear, or should I repeat?
Yeah, maybe if you could repeat, because it is not too clear for me.
Okay, in the anthropogenic upstream, that's new term for me as well, such as multi-purpose dam, tunnels, and irrigation projects development, which directly impact on the downstream country, can this be included in the initiative of cooperation policy, and what international law obligate on their issues?
I think maybe an answer can be that the international water law offers a framework of sharing transboundary waters, and that the main principles guiding the sharing, and also the prevention of impact from an upstream country to a downstream country are the equitable and reasonable use and the obligation not to cause a significant harm. And also it is very important what Dinara said about the due diligence obligation. So really this is a requirement of international law.
Thank you. Mara, we have a few more minutes, and you woke up in the last 10 minutes, audience, with many questions. Ines, question from Ines. Another question for me would be about how to deal between the national local level and the convention. How do you deal when there is a conflict between international and local national level? If the priorities in national level are, for instance, food security or energy security. Dinara Komlan. Dinara, go ahead.
Dinara, yes.
I don't think that there is a possibility of conflict if your monistic work, when the international law has a priority under national laws. And actually, this is they are very much connected. You cannot implement conventions at international level if you are not implementing it at national level. So, and you cannot enter to the convention, to accede to the convention, not aligning your national legislation with the provision of the convention, or at least not making inventory what you have to change in order to comply with the convention. So I think when you have these difficulties, and if you're committed to the international convention, you have to work at the national level to meet these priorities related to different national interests.
Good. Okay, thank you, Dinara. We have a few comments from Riyad Avaya from Palestine. Sharing data depends on trust and sovereignty. Implementation of a related resolution to water or other issue is the key in compliance. And we have a question from Nukem Foni. Commenting on Mara's question, data sharing is definitely a problematic issue. Apart from the compulsory data that is required by the convention to be shared accordingly to Comlan, what are the measures put in place to remedy the situation in case of dispute and non-compliance? That's an interesting question. Therefore, what are the remedies in the question of that? Would be the last question to our participants, to our panelists, and then I'll ask them just for concluding tweet. But could somebody reflect on this question? Over to you.
I think what I would say that it is a key not to start to build a trust between countries to share the data. Also, as Comlan said, it is important to identify these common benefits so that the sharing of data can be a sort of a win-win possibility for the countries to share this data. So,
is the concluding tweet from your side, win-win solutions for the countries, huh?
Exactly. For me, I will say, yes, of course, the Water Convention provides some provision on dispute settlement, but I will say that the most important is not just to resolve disputes, also how to prevent this conflict and help those countries dealing with this. And for this, I will let Dinara, because the implementation committee is really the very, very good tool to support countries with those non-compliance and so facilitate this. For that, Dinara, please.
Over to you, Dinara.
Thank you, Komont. And I think it's indeed very, very important to talk about this innovative, non-traditional way of dealing with non-compliance, managing compliance, I would say. And the convention does everything in order to help countries to improve their capacity to implement, because most of the time the issues related to disputes and non-compliance relates to lack of capacity, not bad will or bad behavior of the countries. And we discuss a lot about the data sharing, and I think in our digital world, it's very important to talk about also remote sensing data that can help to neutralize situation. And I think we should combine the remote sensing data with the field data to verify it. And this will be one way of building trust to the data, and another way it's a co-production of knowledge and data. And I think it's very important. And in our region in Central Asia, we're trying to involve also local population in monitoring the state of the RLC bottom, for example. So they feel some ownership that they're also contributing to this area. So I think it's a lot of different ways how we can build this trust, but also improve the quality of data.
Thank you. Thank you, Dinara. We had win-win solution search from Mara. We have a better prevention than dealing with conflicts for Comlan. We have from your side some sort of tweet which would go along these lines. If we cooperate more, we will reduce chances for confusion and political disputes where they may not exist if we have more data, more engagement, and more dialogue. Therefore, it's very pertinent. And we had a good comment from Raquel from IGRAC indicating that data should be shared on different level, and it could be a sensitive issue. We'll summarize it later on. And with these 3 tweets, win-win, prevent, share and engage in order to diffuse political conflicts and misunderstandings, I would like to conclude today's session, to thank you all for sharing this interesting 1 hour with us with excellent panel.
Thank you, all the speakers and the excellent questions that we have from the public, and many thanks on behalf of the Geneva Water Hub and DiploFoundation. Thank you.